Good morning and welcome to the David and David on Real Estate podcast. And we have Jake Newton back with us again, and we're going to be talking about litigation. Jake, welcome back.
Glad to be back.
Great to have you, Jake. And we talked in a prior episode with you. I think we focused a lot of defaulting buyers and but a lot in builder transactions because we're seeing a lot of that now. So, but you're recently involved in a court decision where you were dealing with a builder and you're fighting over deposits and things like that. So the issue became anticipatory breach and how that's communicated, things like that. I think it was very interesting. So I think I'd love you to take us through that case, and because there's so many issues that come out of that I think are important.
Sure. And I think last episode we spoke a lot about best practices for real estate agents, but in this one it's more about best practices maybe for real estate lawyers, and dealing with an anticipatory breach and how to respond to an anticipatory breach. And so in this case, my clients were purchasers of a pre-construction home. So not a condo, but a luxury home. I think it was between $3.5 million in Oakville. That's to be built by a builder. The contract was probably signed somewhere late teens, 2018, 2019, 2020, to be built maybe over the next 3 or 4 years. My clients were selling their house, selling their property in the United Kingdom in order to be able to afford the purchase. And so there was a deposit schedule. I think it was, 3 deposits of $50,000 each and a final deposit of around $200,000. And then on the closing date, the balance would be paid. And so my clients listed their UK property for sale. They signed the contract. They paid the first 2 deposits totaling $100,000. But they had some issues in selling their UK property. And so they weren't able to raise the funds to pay the 3rd deposit and the 4th deposit. And so when the 3rd deposit deadline came, they were forthright about it. They communicated with the vendor. They explained, we don't have the money, but we're going to get it. What can you do? And that's, touches on, I think, the podcast episode 2 episodes ago about good faith and developers seeing the situation that's unfolding with the real estate market and saying, what's best for everyone here. And so the vendor retained counsel, and the litigation lawyer on the other side wrote letters on behalf of the vendor, even though it was a live deal, and proposed, and obviously with their client's instructions, an extension of the 3rd deposit deadline to the same date as the 4th deposit deadline. So they just extended the 3rd deposit to be paid with the 4th deposit. And so just to explain, my clients had anticipatorily breached the agreement, which would entitle the vendor to terminate the agreement and retain the deposits and potentially sue them, because they had told the vendor that they wouldn't be paying the 3rd deposit on that deadline. They're saying we're not going to be complying with the terms of the agreement, and that constitutes an anticipatory breach. When the innocent non-breaching parties faced with an anticipatory breach by the opposing side, they have to make an election. They can either elect to disaffirm the contract, to terminate it in response to that breach, where the deposits will be forfeited, and they could potentially sue for damages, or they could elect to communicate the affirmation of the contract, the opposite, to say, no, we're going to keep it alive. We're going to, push you to perform the contract. And that's really the test to determine whether or not there was an affirmation or a disaffirmation, whether or not the vendor pressed for performance. And so, because sometimes it's not so clear, sometimes people don't realize what they're doing when they're communicating with the purchaser. And that's kind of what happened in this case. And so by communicating to my clients that they wished for them to pay the 3rd deposit on the 4th deposit deadline, they were in a way pushing and pressing for my clients to perform the contract. And so the court found ultimately that that was an election to affirm the contract and keep it alive. At the 4th deposit deadline, the same thing happened. My clients hadn't sold their UK property. They hadn't raised the, I think, $250,000 that they needed in order to pay the third and fourth deposit on the fourth deposit deadline. They were forthright about it. They were forthcoming. They explained to the vendor's lawyer, same thing. You know, we don't have the money. We do want to close. You know, what can we do here? And the vendor's lawyer wrote a similar letter. They said, you know, we'll extend the deadline for the third and fourth deposits now to, you know, maybe 15 days down the road. And again, in doing that, the court ultimately found that they were pressing for performance and they had affirmed the contract. And it's an important tenet, I guess, of the anticipatory breach law, that once you make an election to affirm or disaffirm, you cannot later on, you know, change your election. It's kind of set in stone once you make an election. And so once my clients had breached or anticipatorily breached by telling the vendor that they wouldn't be paying the third and fourth deposit on the fourth deposit deadline, they could not later go back and say, well, now we want to accept that breach and terminate the contract. They would have to wait for a further breach. Well, that day came. And so the new deadline, maybe 2 weeks later, came, and about 3 or 4 days before that deadline, my clients wrote to the vendor's lawyer and said, look, we still don't have the money. We haven't sold our property. We're trying. You know, someone bought the property and then defaulted. So, you know, we're doing our best here. And the vendor's lawyer responded and said, you know, the deadline that's in 3 days is the deadline. And if you don't meet this deadline, we're going to deem you in breach of the agreement. These are her words, and move to terminate. Deadline comes, my clients don't pay. Silence. 6 or 8 months down the line, the purchaser sells the property to somebody else, to a third-party purchaser. They then start a lawsuit against my clients and claim for forfeiture of the deposit, the $100,000 that was paid, plus the difference in the sale price, which was something like $400,000. What I argued, and what kind of the law supported, is that 3 days before that final deadline, the purchaser, so rather the vendor, was pressing for performance. They were saying, no, you still need to pay on the deadline. That's 3 days away. You've just anticipatorily breached by telling us you won't pay it, but we're telling you, you need to pay on that deadline. And if you don't, we're going to move to terminate. That was an election, and they're bound by that election. They cannot go back and accept that anticipatory breach to terminate the contract in the future. They'd have to wait for a new breach. Then on that deadline, 3 days later, there was a breach. My clients didn't pay by the deadline. And the law states now that the vendor was put to an election on that date, but they didn't make an election. They did nothing. And their silence went on for so long that the court agreed that it was tantamount to affirmation. They were communicating implicitly to my clients that they could just pay the full purchase price on the closing date. They didn't take proper steps to terminate. And, you know, I'm not privy to what the vendor's instructions were to their lawyer, obviously. But the terminology, you know, we will move to terminate, implies that they'll actually have to take, that they're going to take another step. And so I'm not sure if it was a mistake or miscommunication or what happened on their end. But what I argued successfully was that by selling the property to a third-party purchaser, the tables had now turned. The vendor was now in breach because they couldn't perform the contract. They couldn't transfer title. And I immediately ran out and accepted their breach and said, we terminate. You know, this is a disaffirmation of the contract in the face of your breach. And we, you know, demand repayment of our deposit. And the court agreed.
Yeah, I love it.
Amazing. So when we're back 3 days before that closing, if the vendor's lawyer said, you've told us you can't close in 3 days, so and that's an anticipatory breach by the buyer, and we're accepting that you're breaching, and we're therefore terminating, it's case over, right?
Correct.
That's it. They keep the deposit, they reserve the right to sue for damages. They may get all that damages, right? If, you know, subject to mitigation rights, and you can argue mitigation, stuff like that, but they would win, right? But they never communicated that they actually terminated the transaction. So then they go sell it, which makes them in breach. You turn it completely around and say, now an anticipatory breach on your side, and we're accepting that, and we're terminating. And judge says, great, yep, you get your money back.
That's exactly right. And another option would be not necessarily to accept the anticipatory breach 3 days before, but when that deadline, which was a hard 5 p.m. deadline in their letter, when it came and when it went and there was no payment, a simple one-liner email or letter to my client saying, you never paid by the deadline. We accept your breach. The contract is hereby terminated. One sentence. And again, my clients had no argument.
Right.
And so a couple podcasts ago, I told you, sometimes I get calls from purchasers who are in these situations, and I do a quick run through and I see, what does the contract say, or what's the situation? Show me the correspondence between the vendor or its lawyer and you, and let's see what they did here. Because sometimes there's openings. I think sometimes other lawyers, hear the facts, hear that there's a purchaser breach, and they say, well, I can't do anything for you. There's nothing to be done. But if you peel back sometimes and take a good look, sometimes there's some gold there.
And
Yeah.
Jake, this all goes back to how we started the first podcast, is that, you want to negotiate, you want to act in good faith, but there's certain rules and regulations and procedures that both parties need to follow to make sure that their rights are upheld in these agreements. And this is like a perfect example of a huge not a breach, but a failure to communicate on the part of the purchaser, not the purchaser but the seller, right? And big consequences to failing to communicate. And probably ripple effects are going through the legal community, because I could see a lot of these cases probably happening where the injured party fails to actually communicate that stern deadline of that breach, right?
Yeah, and I don't think people necessarily consider that sometimes it actually makes sense to affirm the contract. Sometimes, people think that they should just terminate right away. And you need to look at the context. You need to consider, and I think this is a perfect example of when, affirmation was maybe appropriate, or maybe the builder really should have thought about, do I really want to terminate? Because there was, and the vendor would have to do maybe some due diligence to confirm this, because everyone, will say anything, but there was motivated buyers. The market was, there wasn't other purchasers lining up to purchase the house. It took them 6 or 8 months to resell it. As soon as my clients sold their UK property, they'd have the funds. It's not necessarily, you're not necessarily better off as the vendor to terminate, accept, the forfeiture of the deposit and go through the litigation to sue somebody. If you have a motivated buyer who actually looks like they will complete the deal, you can avoid a lot of headache, a lot of stress, a lot of money and legal fees by working with them in good faith, providing further extensions. And, maybe that means getting, can you pay a $10,000 further deposit? You further secure yourself so that, and you don't give them 8 months to pay, keep 1 month from now, 1 month from now, you work with them on a month-to-month basis, pay more deposits to us. And if they haven't sold their property and can't make payment in 6 months, then you make a clear termination if that's what you want to do. But in a situation where you actually have a purchaser who you think will close, you don't need to terminate. I mean, I think that's more advice from real estate counsel as opposed to litigation counsel on what the needs are of the client. But I just think that's something that a lot of vendors don't ever consider.
Yeah, and on the buyer side of it, like I try to avoid a clear anticipatory breach if I can. So, if I'm a week before a closing and I know my buyer's scrambling to get their financing and they're trying to do it, but they're not likely to, or they may not be able to, then I'll communicate that to the seller's lawyer saying, hey, we're trying to get our act together here and we might not be able to close. We'll let you know, we'll keep you posted, because I don't want to get the letter back saying we're accepting that as, I don't want to say we can't close, but I want to give them, we have a duty to act in good faith too, and to not tell them, on the day of closing, oh, by the way, we can't close today, and please be nice to us and give us an extension. So I try and give them notice, but I want to be careful in my language to them, because I don't want them to say that's an anticipatory breach and we're terminating you when it's a week before. Because maybe we get our act together in that week, or we come back to them, the day before closing. We tried that we know we need 3 days, or we need a week. At least we know maybe at that point what we really need. And then a builder's always going to say, look, if I can give them 3 days and they're actually going to close, or I can give them a week and they're actually going to close and they can show me they have a commitment, like, they'd rather take that than terminate you, right? They want the deals to close. So we got to find a way to act responsibly and reasonably, but not expose our client to say, oh, we're not going to be able to close on Friday, terminate me. Like, that doesn't help anybody.
Yeah, I completely agree. And I see maybe less sophisticated real estate counsel make that mistake where they write haphazardly and don't understand that they're actually, maybe committing an anticipatory breach on behalf of their client by writing loosely, and you need to be very careful.
Yeah. It's like having your cake and eating it too, right, Jake? I mean, if you're the seller, in this case, I could see why they wouldn't communicate a breach or injure to the contract, because they're hopeful that the buyer will come through. Maybe they'll sell their house tomorrow. Maybe they'll sell a house in 30 days. Maybe they'll sell the house in 60 days. Maybe we're gonna hear back from the buyer, and maybe they're gonna correct their breach, right? But I also see why that's an issue. It's like having your cake and eating it too. You're trying to sell it to another party on the open market, and you're hoping that the buyer comes back at the same time. So it's like, you're trying to play both sides of the coin, and that's not right.
I agree. I'm not sure exactly what the situation was in this case. I mean, if they found a new purchaser, they could have communicated and said, look, you haven't paid the deposit. The deadline was 5:00 p.m. 6 months ago. To be clear, by the wording of our letter 3 days before then, it was terminated. That's what that's our position. But if it's unclear for any reason, it was, and that again would have been the death knell. That would have been enough. And so I'm not sure that they're playing kind of two tracks here. I think the wording of their letters was a little bit loose. And that's why I said I think that this more is best practices with respect to real estate lawyers, or sometimes I guess litigation lawyers take it upon themselves to write these letters. I leave it to real estate counsel, because it's, they should have, like David just said, it's standard for them. It's something that they deal with every single day. They should have a clear terminology. The deal should be dead, and then I come in. But you got to be careful.
Yeah. And the language really matters. So then the contract really matters, and time of the essence, and all those concepts really matter. And you got to be clear in the communication. And then again, like we talked about in the last episode, every piece of communication between the parties becomes relevant when you get to trial. Like every email, you got to keep track of all those things and what's communicated and when it was communicated, because you never know what that ultimate issue is going to be that proves your case one way or the other.
Yeah, and in this case, my clients were writing their own, emails, their own correspondence directly with an experienced lawyer, and so you don't get the benefit of the doubt when a lawyer is writing letters and writing emails, and the terminology isn't clear. If the vendor himself or herself was unsophisticated, writing their own letters, the judge might have seen it differently. They might have said, well, they clearly meant to terminate, or that was the best way that they could communicate their acceptance of the breach, acceptance of the repudiation and the termination. But when you're a lawyer writing that, you don't get, and you shouldn't get, the benefit of the doubt. You should, a judge should read the words exactly as they're written and interpret them, in that fashion.
Yeah, Jake, can you just comment a little bit on this case and the one we talked in the last episode, the small claims court case? These go to a court decisions at the end of the day, and you're successful in both of these. Congratulations, which is great. But maybe just comment on what happens in terms of costs and what that
Good
process
question.
was for these buyers in both the small claims situation and on this one. Like, what type of costs are involved and what type of costs are actually awarded?
Yeah, so with the latter case, the one we're discussing on this podcast here, opposing counsel was, very professional and sophisticated, and the judge invited us, if necessary, to make written submissions on costs, but invited us to also come to terms on costs and what was an appropriate amount. And so when you attend a trial, or in this case, it was a summary judgment motion, you bring with you a cost outline or a bill of costs, which sets out the full cost, the full indemnity costs that your clients have incurred at each stage of the litigation. And you typically, the winning party is typically entitled to costs, subject to any other, nuances of the case. And you're typically entitled to around 60%, which is the partial indemnity amount of your total cost. And so in some cases, you actually make submissions and you make arguments to the judge on your bill of costs. Sometimes you don't know who's won at that point in time, because the judge will reserve but say, let me hear your costs in case you win, in case you're the winner. And so you need to make sure that you give an accurate, obviously, number of what your costs are. In this case, there was, two partners and a junior lawyer who was probably, around my vintage, opposite me. And so, quite a bit more money was spent on there, and they're a very big law firm. And so it wasn't very difficult for me to come to terms with the opposing lawyer and say, look, my bill of costs are 1/3 your bill of costs. How are you going to reasonably argue before the judge that mine are inflated, right? I think it's, if anything, mine was deflated, right? That my amount is very reasonable. And I think the judge is going to see that, because I already have your bill of costs. The judge has your bill of costs, and mine was literally 1/3 of yours. So it was pretty easy to come to terms in that sense.
Can you
So
give
Jake,
us
you
a
just got
sense of the
60%
dollar
of what
amounts?
your costs were in that situation?
I'm just trying to think. So somewhere around 60 to 70% of what my clients' costs were. Yeah.
Okay.
Can you give us an idea what the costs actually were? Like, so just so people that said how expensive it is to litigate.
For me, I mean, I try to work as efficiently as possible and as reasonably, at reasonable rates. The total cost was around $35,000 or $40,000
Oh,
on
that's
my
very
end.
reasonable.
But on the other end, it was over $100,000, or right
Right.
around $100,000.
Right. But here, your clients, would have spent 35,000 or 40,000 on you, and they recovered hundreds of thousands of dollars in this decision because it went their way. But there was always that risk that it wouldn't go their way, that a judge would find otherwise, or if somewhere in the communication the builder actually terminated, then I guess if you actually had a piece of evidence that they actually did terminate or communicate to terminate, your advice to your client would be like, let's not go to trial. We're going to lose. We got to try and settle this, I imagine.
Yeah, so I won't say exactly what my advice was, but in a similar circumstance, in a general circumstance, first of all, my clients didn't start this litigation. We terminated because I felt we could. I felt there was a shot to say, look, we can argue that they breached, we can terminate, but we didn't start a lawsuit for, repayment of the deposit. They sued us for the full forfeiture of the deposit and the damages. Do I encourage clients in my client's position to start a lawsuit where they're then going to face a counterclaim for $500,000? I'll let you read between the lines. But when you're facing a lawsuit like that, of course you're going to throw the kitchen sink back and counterclaim for what you think you're entitled to. And so I guess maybe we'll leave it at that. On the other end, I actually just submitted on the small claims court matter we were discussing. I actually submitted my written cost submissions because we weren't able to come to terms. Again, the judge invited us to come to terms, but we weren't able to. It's interesting because the money is far, it's lesser than what the other, $500,000 at play in the other action. This is a commission. Obviously, it's in small claims court. I think the commission was $32,000. But small claims court is tough because my clients probably incurred more than half or around half of what the claim was in me representing them, because it was a 2-day trial. I generally budget, a full 2 days for 1 day of trial prep. And so you're looking at, what is that, 6 full days of preparation for 2 full days of trial. It adds up, and it's unfortunate because it's getting, it's hard to litigate in small claims court. It's hard to have a lawyer be worth it, even if you win. I actually just read the other day that they're increasing the monetary jurisdiction of the small claims court to $50,000 come October, which I welcome, and it's really important.
Yeah, that's great.
But the rules are difficult in small claims court. Your cost award is capped at 15% of the claim. So 15% of this claim is something like $5,500. But what are my clients supposed to do? I don't think that they would have necessarily been able to succeed and make the kind of nuanced legal arguments if they acted on their own. But even if we recover the full $5,000 in costs, they're still looking at over $10,000 themselves, and so that it's a big problem. And so there's kind of 2 or 3 ways that I deal with small claims court differently, or what I almost always do in small claims court to help protect my clients, which is I make reasonable offers to settle. The rules of small claims court allow you that if you make an offer to settle and it's not accepted, and it's open for acceptance until after the commencement of the trial, and then you go on and beat your offer with some nuance, you're entitled to up to double of that 15%. So we now are arguing that we're entitled to more than $10,000 in legal costs, which puts my clients in a much better position. But of course, they had to make a reasonable offer. We had to beat it, and they had to be open to the idea of that offer being accepted by the opposite party. Now, in my arguments yesterday, because again, I'm trying to recoup as much as I can for my clients so that they're not out of pocket. They have, they're not in the same position maybe as my other clients who bought this $3.5 million house. And so I've made some arguments that I found some case law to argue that because I had a husband and wife defendant clients, 2 clients, that it's possible that they're both each entitled to that 30% cap, which would bring us up to 20,000 and change, which is beyond what we're actually asking for. You can also make arguments that the failure to accept our reasonable offer was an unreasonable act by the opposite side. And part of the law on doubling the 15% cap is found in Section 29 of the Courts of Justice Act, which says that the judge can increase that 15% cap if the other party is acting unreasonably. And so it's kind of a double point, that it's not just the rule that says if you don't accept the offer that you can increase the award to 30%. It's also the unreasonable action aspect, where I argue that not accepting that offer was an unreasonable action as well. And I see some case law that supports that position, and I'm just trying to throw the kitchen sink at it to see how to put my clients in the best position possible, basically.
Yeah, it gets complicated. So here, you're trying to save your client $32,000 that's being claimed in commission. You're spending $15,000 of your time to do that, and you're successful, but you're trying to recover that $15,000. So even if you can't, the client's still ahead, so they're not paying the 32 because you won, but it's still going to cost them potentially $15,000 or something in order to get there. And then there's the time you got to spend to argue the costs too, right? Like there's a time element in that too. So it's not an easy process when you go to litigate. Even when you succeed, there's potential costs.
That's right. And I get calls from people who, are facing or, have claims for, $10,000, $12,000. And I tell them it's not worth it, but you're capable. Most of these people are more than capable. The small claims court is designed for self-represented litigants, where people can get justice without the cost of accessing that justice. And so I have a link that I send people to in these situations, and I say, look, here's the link that tells you step by step what to do. Write your claim as best as you can, submit it on time. Here's the portal, here's the information, and go do your best. You don't want to pay me $15,000 to go collect $12,000. And most of them take that kind of summary advice and go and they're successful. That's all, they're capable, and you don't necessarily need a lawyer in these kind of smaller issues. It's clearly, the facts are clear. The rules in court are a bit looser, and the judges, maybe it's not fair to say that they help you, but they help get you to where you can help yourself, to give them credit. And I think that's good for our system, because I don't think our system works if they're forced, if litigants are forced to hire me at my rates, which are lower than other lawyers' rates, in order to get justice. People shouldn't be out $10,000 because it doesn't make sense to fight for their $10,000.
Yeah, but look, a self-represented client in that particular case would not have figured out, I should ask for the phone logs and see how long those conversations were, right? And unfortunately, they probably would have lost if they were self-represented, right? So, that's an issue too. So it's, good on them for retaining you on this one. But everybody has to understand, like, even when you have all the law on your side and all the facts on your side, a lot of times you're better off settling, because of the risk factor, the costs involved, the timing, and everything else. So, and that's a tough thing to explain to a client, especially when you think they've got all the facts of the law on their side, but it's still worthwhile to make an offer and settle it.
Definitely. And on top of that, when I have plaintiff litigants, it's going back to the discussion we had, I think, 2 podcasts ago. You can't get blood from a stone. If you drive this defendant into the ground, with $50,000 of legal fees, you go to a trial, you spend $100,000 to get to and through a trial, they're gonna have to pay the same thing. If their lawyer, is thinking right, he or she's gonna get a deposit or further monetary retainer prior to trial, because they want to ensure that they can collect and not work for free. And then you get a big judgment. What are you going to do with that judgment? It's just a piece of paper that says you're entitled to X dollars. You actually still have to go enforce that. Do you know where their bank accounts are to garnish their, or where they work to garnish their wages or garnish their bank accounts? Is there money there? I often do title searches on potential defendants to say, look, let's see the equity in their home. And obviously, these people are being sued. Oftentimes they got second mortgages, third mortgages, where they have literally negative equity in their home. And I say, okay, you can line up. You're not going to get ahead of, TD Bank. You're not going to get ahead of private lender 1 or private lender 2. And so if they're going to offer to pay you even 30 or 40 cents on the dollar, I know that sounds like offensive, but it's potentially better than paying me that 30, 40 cents on the dollar and you collecting nothing. You got a piece of paper that's nice. It says, the judge stamps it, signs it, you got a judgment, but it's not worth the ink it's, the paper's written on.
Right. Well, this has been great, Jake. Good.
Yeah, really
legal advice and practical advice.
For sure. And it puts everything that we teach, David, into context as well, and into a framework that people can really understand and see what the other side of it from a litigation point of view looks like as well. And I'm so glad that we got into costs and how that works as well, because I think it gives everybody a really clear picture of what not to do in certain circumstances. And to David Korman's point, how important it is to, really work through some of these situations in good faith and come to an agreement as soon as possible to move things along and to have a successful closing.
Yeah, I'd say about 99+% of my files settle. I'd say when people hire me, I say, you're hiring me to get a settlement. That's court. It's not the last resort, but it's not the happy resort for anyone here. I close deals and I turn over files and take a new file. You don't want to push things to litigation unnecessarily, or you don't want to prolong litigation unnecessarily. If the money's there and it makes sense, make a business decision and take it and run.
Love it. Jake, thank you so much for your time today. Want to encourage all our viewers, if you have questions, please email us. Post comments down below as well. We want to hear from you. And Jake, thank you so much for coming on the podcast and sharing your experiences with us.
Yeah, thanks for having me. It's been great.
A pleasure. Thank you, everybody.
Thanks, Jake.